Pay us one money. You made us work. Why are you not paying us? This is not too much money for culture management to pay. Hi guys, welcome to BTM Afrika, NYDJ here. Now guess what we are looking at today? In our day-to-day activities, a lot of things happen, right? So imagine your brother asking you to go carry out an assignment for him, and then you go about, do everything with your own money, carry out the process, you are done. Time for your brother to pay, and your brother says, the money, ashi. Can you imagine how that will feel? Well, allegedly, that is the situation we have at hand here. Blay and Associates are actually suing Afrofuture Ltd and Culture Management Group. The question is, why are they suing them? Why would a law firm sue their client? Well, I'm breaking them down here on the channel on BTM Afrika. Welcome to the channel. If this is your first time, thank you. If you're a regular, thank you. But please remember to subscribe, hit the notification bell so you get all the updates once they are in. Welcome to BTM Afrika. All right, guys, so welcome back. Now let's break everything down in perspective. What is happening between Blay Associates and then Afrofuture Ltd and then Culture Management Group? If you're asking yourself who is Blay and Associates, well, they are a law firm, a renowned one, because you know a number of names from there. I don't want to get into that. But Afrofuture, yes, they are big. They are a big event organization company right here in Ghana. Of course, in America, they do other things as well. But in Ghana, we know them for organizing one of the biggest December events in Ghana. Initially, they were the organizers of Afrochella, which eventually became Afrofuture, because remember, there were lawsuits, Coachella and all that, the name, because Coachella felt these people were trying to ride on their name, Coachella and Afrochella. There were a lot of legal issues. Eventually, they had to change their name to Afrofuture. In December, they organized one of the biggest events in Ghana as well. So they are into event management, and of course, that's what they do. So Blay and Associates are saying, listen, these are a group of individuals who actually requested for our service because they found themselves wanting a legal issue, and we had to actually step in to represent them as lawyers. But unfortunately, these people are refusing to pay us, and so they've taken them to court. So imagine a lawyer or a law firm suing their clients for recovery of their own money. Now, let's break it down so you understand whatever is happening, because typically everything that these people are seeking for actually get into the statement of claim. Now, this is what they are saying. They say that the plaintiff avers that the defendants engaged the professional legal services of the plaintiff's firm to act as their legal representatives in a suit instituted before the High Court of Justice with suit number concerning a dispute arising from claims of copyright and trademark infringement. So Afrofuture and then Culture Management actually sought for the services of this law firm to represent them in a copyright infringement issue. So there was a lawsuit resulting from a copyright and infringement trademark issue, and they had to request for the services of Blay and Associates. That's what they are saying. They say that the plaintiff avers that during the course of negotiations and upon the full performance and completion of the legal services rendered, the defendants expressly acknowledged and agreed to the payment of legal fees in the sum of 52,000 United States dollars. So this is the legal fee that Blay and Associates were charging. And the defendants agreed to pay this amount of money, $52,000, exclusive of all applicable taxes. The plaintiff further asserts that the said amount was initially agreed upon as consideration for the professional legal services provided, including but not limited to legal representation, advisory services, and all ancillary matters related to the suit in question. So these people actually, or should I say the law firm accepted to actually represent these people. Anything regarding that particular copyright and trademark infringement issue, they were going to represent them in court. Both parties, that's the plaintiff and the defendants, agreed to an amount of $52,000, which was going to be the legal fee for this particular law firm. Now, let's get to the point 6. After point 5, we get to point 6 that says that the plaintiff avers that following extensive deliberations and negotiations with the defendants, it mutually agreed for a discount of 22,000 state dollars. That's the United States dollars, 22,000. So they both agreed. For whatever reason, they agreed that, okay, we're going to charge a discount. We are going to give a discount of $22,000, meaning that the amount of money they are supposed to pay now is $30,000. Now, this he says that the plaintiff says that this concession was made in good faith and in furtherance of an amicable resolution regarding the payment of legal fees without prejudice to the plaintiff's right to full compensation for the professional services rendered. So, I mean, Blay and Associates did not owe any responsibility to say that we're going to reduce the amount of money because they had agreed on the $50,000. So they didn't owe the defendants any reduction or any discount as is being mentioned here. But because of, the relationship that exists between them. Now, for those of you who know the relationship between Blay and Associates and Culture Management and then, of course, Afrofuture Ltd, you even be surprised why they are in court because these are bodies like they are family. But unfortunately, they are in court. Now, they say that they did this. I'm talking about the law firm. They say they did this because of, for an amicable resolution to whatever it is that was happening. Now, the plaintiff further avers that pursuant to the mutual written agreement through a legal engagement letter between the plaintiff and the defendants, the revised legal fees after the deductions was $30,000, which was agreed to be paid in 4 equal installments over a specified period ending July 2023. So they had agreed $30,000 deal. We're going to pay it and make sure that we pay it by the end of July 2023. It was expressly agreed that the said installments will be made at regular intervals between April and July 2023. The plaintiff says that the payment arrangement was accepted by both parties as a binding obligation. Now, once you agree and it becomes a binding obligation, it means that you have no choice than to honor it because both parties have agreed that we are going to do this. But that didn't happen. One party still refused to actually make payments. That's all the allegations they are making in their statement of claims. Now, 9 says the plaintiff further contends that the defendants haven't engaged in the firm's expertise and legal representation duly advised and represented in the said proceedings in accordance with the applicable laws and legal practice. So they went ahead, carried out the job for them because they have agreed to do that. But unfortunately, the plaintiff avers that despite the express agreement on the payment terms, the defendants have only made a payment of 44,400 Ghana cedis. Out of $30,000, the defendants have made a payment of only 44,000 Ghana cedis, and that was on the 22nd of May 2024. That was almost like a year after the time of agreement, as in they were going to pay by the end of July 2023. Now, they paid 44,400 Ghana cedis in May 2024, and since then, they have willfully neglected, failed, and or refused to make any payments whatsoever towards the settlement of their outstanding indebtedness. That's why they are in court. $30,000, they've paid 44,400 Ghana cedis. Now, after this, they have been back and forth trying to make sure that they pay the money. Unfortunately, they are not paying. So the point is, why are they in court? What do they want the court to actually do for them? Now, this is where we get into it. It says the plaintiff avers that it duly served a letter dated 12th October 2023 to the second defendant, which constituted a final demand notice requiring the said defendant to effect full payment of the sum of $36,000. Okay, so $36,570 inclusive of all applicable taxes. So when they serve them that demand notice obviously asking that, listen, this is the last time, pay me this money or I take you to court. They send them to them because they feel, listen, you've not paid us this much, and then it's accruing because taxes and all that. So you need to pay in addition to this amount of money. Unfortunately, the plaintiff says that till date, send me no say, Culture Management, Afrofuture, like they don't care. Should I say they don't care? They've not made any attempts to actually settle it or reach out to them or have any conversation with them. And that's why they are in court. Now, the question is, what exactly is this law firm asking the court to do for them? Imagine a law firm suing their client because the client has refused to pay money. Now, that's what they are actually requesting for. That's the reliefs they are seeking. One is for the recovery of the sum of 36,567 United States dollars, being value of services rendered to the defendants by the plaintiffs dated October 2018 to March 2023. B, the recovery of interest on relief. So even with the amount of money they are seeking for, they are seeking an interest on that at the prevailing commercial bank rate. Again, they are seeking for the cost incidental to the suit and any other further relief that the honorable court may actually deem fit. So this is why they are in court. All they are saying is that pay us one money. You made us work. Why are you not paying us? This is not too much money for culture management to pay. I mean, it's not even have to put $40,000, but a bill $40,000. I'm joking. But hey, that's why they are in court. They say pay us our money. $36,000 plus interest at the current, prevailing bank rate. Pay us this money and we are out of court. Now, the interesting thing, this notice I'm getting is actually coming from a substituted service. It means that they made attempts to actually sue these individuals or these companies, but they couldn't read them. So the court actually asked that they could actually serve them via social media and via their WhatsApp numbers. And that's how come this suit is out here today. So Afrofuture, culture management, I know you guys are cool, Blay Associates. It's family. I just hope they're able to settle this, or maybe they may meet them in court somewhere in March 2026. Whatever the updates may be, we will share that with you here on BTM Afrika. My name is NYDJ. I hope this breakdown helps you to understand the matters as they are. Please subscribe to the channel, hit the notification bell, and of course, for those who like to advertise with us, please give us a call. Send us an email. Let's advertise the products on this channel. We get something. You also reach your audience, and you also make something. Thank you for watching.